Okay, Dan, you're on.
All right. All right, let me call the Monday, July 18th meeting of the Inland Wetlands Commission of New Canaan to order. Will the secretary take the roll, please?
Absolutely, Mr. Chair. Mr. Stepanek?
Here.
Ms. Jameson? Here. Ms. Kirby?
Here.
Mr. Perkins?
Absent.
Ms. Brunali?
Present.
Mr. Sillo?
He's there.
Here.
Okay, thank you. Ms. Woike?
She's absent.
Ms. Sanford?
Here.
Thank you.
All right, I wanted to just quickly tell everyone we have two new appointments to the commission. Priscilla Volke has now been made a regular member, and we've appointed Katie Osley as an alternate member. Both of them, Priscilla's out of town and Katie needs to be sworn in, so they'll be at our September meeting. Approval of the agenda. Does anyone have any comments? Can you have, Beth, did you, oh, yes.
I was going to move approval.
Oh, go ahead, I'm sorry, yep.
I'll second it.
All those in favor, raise your hands.
Aye.
Aye. Approval of the regular meeting of June 20th. Any comments? Can I see a motion?
I'll move to approve.
Peggy? I'll second it. All those in favor, raise your hands.
Aye.
Dan,
Yes,
I approve to the extent I was present at the meeting.
okay. Site visit minutes of July 6th. Same ritual. Any comments? If not, can I hear a motion? Who wasn't at the site visit?
Was at the site visit.
I was not there.
Peggy wasn't
So
there.
all motion.
What'd you say, Anthony?
I'll motion for it.
Oh, you take a motion, okay.
And I'll second it.
All right, Beth seconds it. All those in favor, raise your hand. Applications were received.
Oh, I'm sorry, Dan. I'm abstaining because I wasn't at the site visit.
Same with me.
Applications to be received and if complete scheduled for regular meeting September 19th. Let's keep in mind the meeting in August, so next one will be September 9th. Application number 2301, 82 Brockwood Lane, Kensho Trust, and the agent will be David Rucci. We'd like to schedule a site visit on Wednesday, September 7th at 7:30 a.m. Can I have a raise of hands of who can make that site visit?
Who
I can.
cannot or can?
Can. I can, Beth can, Anthony, yes?
Yep.
Where are we? Beth, can you do it? Okay, that's 4. Angela, no.
Well, I will try to make it, but if I have to go into Manhattan that day, I won't be able to. So please don't count on me, but I will try and make it.
And what about you, Peggy? Would you?
I don't think I can, Dan.
You can't make it, okay. So that's 4. We got a quorum. All right. I wanted to tell you right off the bat that number 10, 11, and 12, application number 2122, 2122, 50, 51, and 52 will not be heard tonight. I'll get to that. But if there's anyone in the room out there listening, we're not going to hear those applications tonight. They're the town of New Canaan applications. All right, number 8, notice of violation. Parentheses, order to halt all work issued to 17 and 23 Hill Street, 72 LLC. Just to remind you, we had for our June meeting, the applicant requested to appear to review written reply and discuss violation activities. The agent representing the applicant was Attorney Smith, Christopher Smith. So on 8A, applicant to report back on status of fill removal and restoration of disturbed area. And I understand, Attorney Smith, you'll be reviewing the status of the disturbed area. Is that correct?
That's correct, sir. Yes.
All right. So you have the floor now.
Excuse
Dan,
me,
go ahead,
Go
go
ahead.
ahead, Beth.
before we go further on item 8, I'm just going to recuse myself again from items 8 and 9 on the agenda. I'm going to turn off my video and put myself on mute, and then we'll rejoin the meeting afterwards.
All right, thank you, Beth. Kathleen, do you have something? Okay,
No, I just wanted to get that.
get that in, okay. All right, Attorney Smith.
All set, Mr. Chairman. Good evening, Mr. Chairman, members of the commission, Director Holland and Town Attorney Gelderman. For the record, my name is Chris Smith. I'm a land use attorney with the law firm of Alter and Pearson, and I appear before you this evening on behalf of Hill Street 72 LLC, which is the owner of the subject property. I'd like to indicate that on behalf of the owner this evening, we have Arnold Karp and Paul Stone, both of Karp Associates, Inc. in attendance. We have our professional licensed civil engineer, Derek Dwanis of DeAndrea Surveying and Engineering PC that we'll hear from momentarily. And we also have our professional wetland scientist and professional landscape architect, William Kenny of William Kenny Associates. As the chair indicated, we did appear before you, as you recall, on June 20th, 2022, concerning this notice of violation that involved essentially two activities. One involved test pits that were done on the performed on the subject property, and they were filled in. And another, the second involved material that had been from the crossing, the construction of the crossing that had been approved by the commission, had been stored outside of the designated limit of construction area. I'd like to remind the commission that both Mr. Kenny, our wetland scientist, and Mr. Dwanis, our licensed professional civil engineer, both opine that the activities did not result in an adverse impact to a wetland or water course relative to, again, either activity. Once again, the test pits holes were filled, and the stockpiled material, as requested by Director Holland and instructed by this commission, it consequently was removed, and the area where the material had been stored was reseeded and restored. All of that was done with under the guidance of Mr. Kenny, Mr. Dwanis, and working with Director Holland. What I'd like to do, Mr. Chairman, with your permission, is turn the commentary over to Mr. Dwanis, who will provide the commission with a summary of the material removal and the restoration work that was performed, again, under the oversight of Director Holland. At the outset, I would like to note for the record that both the Army Corps, as well, U.S. Army Corps of Engineers, as well as the Connecticut's DEEP, had no objection to this restoration work that, again, was performed at the direction of Director Holland in this commission. So with your permission, Mr. Chairman, Mr. Dwanis will provide us with a summary of the activity.
That's fine, go ahead.
Thank you.
Good evening, everybody. This is Derek Donay from DeAndrea Surveying and Engineering. So after the hearing, our firm, along with the input from William Kenny Associates, prepared a stockpile area restoration plan, which included both a material removal plan of action and a sketch depicting the approximate limits of fill and stockpile areas to be removed. This restoration plan was then submitted to Kathleen Holland for review and approval. After Ms. Holland approved the plan, Karp Associates then coordinated the removal of the material from the site down to previously existing grade. Our firm then met Ms. Holland at the site on Friday, July 8th, to review the disturbed area and confirm that the material had sufficiently been removed. At this site meeting, it was agreed that the fill and stockpile materials had been removed down to previously existing grade, However, it was also determined that additional medium-sized stones should further be removed to allow more soil to be exposed for seed germination. Also, some additional erosion control measures should also be installed along the downhill side of the disturbed area. Carp Associates then complied with these requests, and our firm re-inspected the site on Monday, July 11th, to review the site conditions again. Pictures of the site were then sent to both Ms. Holland and William Kenny Associates for final approval. At this time, all parties agreed that the disturbed area was ready for restoration seeding to commence in accordance with Bill Kenny's recommendations. Our firm then re-inspected the site on Thursday, July 14th, and confirmed that the disturbed area had been seeded and covered with straw stabilization mulch. Pictures and an inspection summary of the seeding stabilization were then emailed to Ms. Holland for confirmation purposes. So all the work that was approved to be done has been done now.
Thank you, Mr. Donay. In conclusion, at first, we certainly would like to indicate to the commission and apologize. There was certainly no intent to ignore or disregard the commission relative to your regulations with these two activities. And I respectfully submit that we have complied with Director Holland's and the commission's request relative to both of the activities. And finally, I know that there had been an intervention pleading that was submitted pursuant to Section 22A19 of the Connecticut General Statutes, and I would respectfully submit to the commission that the petitioners who filed that intervention pleading have failed to sustain their burden of proof in establishing with expert testimony that the activities involved with this notice of violation have resulted in the unreasonable pollution, impairment, or destruction in the air, water, or other natural resource of the state of Connecticut. And I would respectfully request that the commission find that we have complied with the request in your NOV. And secondly, find again that the petitioners, the 22A19 petitioners, failed to sustain their burden of proof. And we thank you for working with us and Director Holland for working with us to address these issues raised in her notice of violation. Thank you.
Anyone else from the applicant? Attorney Smith, anyone else?
I think we're all set.
Okay, good. All
Concludes
right,
our
thank you.
comments. Thank you, Mr. Chairman and members of the commission. Director
All right.
Holland.
Kathleen, do you have anything to say?
I just would like to review a similar schedule. Derek summarized it accurately in that I actually received the stockpile area restoration plan and disturbance area sketch on June 28th from the applicant, actually from Attorney Smith through Derek and William Kenny, who proposed the restoration plan, and it's a very detailed plan. I had replied to that plan with some conditions that they agreed to and have complied with to date. The side part of this, which Attorney Smith mentioned at the onset, was to make sure that there's a coordination with the Army Corps and the DEP. I did see those communications in email from the Army Corps and from the DEP agreeing that the town issue should move forward and be resolved outside of their regulatory areas. So they did get acknowledgement from those two agencies to proceed. On July 7th, Mr. Carp notified that the fill had been removed, and in accordance with our arrangement, they were asking if we were ready to do an inspection. So on, I think it was July 7th or 8th, I may have a typo there, maybe it was the next day, we did, myself and Joe Zagorensky from the Department of Engineering met with Derek Dennis at the site, along with a CARP representative whose first name is Gordon. So we reviewed the area where the fill had been removed. And Derek mentioned that there was some additional medium-sized rocks that I had suggested and required, actually, ultimately, after discussing it with them, needing to be removed so that we could get some more soil to seed contact without having the boulders in the way. So they proceeded, again, incorporating Bill Kenny's review of the area as well. And they then made the arrangements to have those small boulders removed and put off to a side where they could not be in the area where the seating was to take place. On July 11th, Derek had emailed that the additional rocks had been removed and was seeking an okay to proceed with the seeding and mulching. Bill Kenny had reviewed and provided additional comments and recommended that the seeding proceed according to his professional recommendation. I agreed, of course, proceed with seeding because that was our end goal. They were ready to do the seeding. Mr. Danius also provided photos of the area, and there had been substantial compliance with the grade that had pre-existed, and we were moving forward in a positive direction. On July 12th, I approved the seeding and mulching to proceed, post William Kenny's opinion as well. And on July 14th, which was this past Thursday, I believe, Derek notified the town that the seeding and mulching had been complete in addition to watering, and provided photos. So we are in the correct lane to have the notice of violation resolved upon this matter being complied with, as the commission had directed the applicant to do so at the June meeting, and also that they had agreed to do with. So we are done.
So Kathleen, just to be clear, no disrespect to Mr. Smith, Mr. Carp, I'm just making sure that there was a recommendation that we were to use a third party to oversee this, and that didn't happen, correct? We did it administratively.
The recommendation or the suggestion was brought up at the June meeting, but was not agreed to by or put into a actual plan for the commission to proceed with that. You ultimately dropped that idea, and so there was no third party review. I brought the engineering department out with me and myself, and along with their site engineer, their soil.
So that's interesting. That's just interesting to me because I don't remember. It's fine. Okay, thank you.
Yes, Mr. Commissioner, I'd like to be heard as well. I agree with Commissioner Sillo that I find it hard to believe that the town is not bringing an independent engineer. Mr. Danaeus, if I pronounced his name correctly, has been the supposed site manager for the town for many, many months. These materials, I go by that site every single morning. These materials have been on site for months. So why, as the site monitor on behalf of the town, has Mr. Donay not brought this to the attention of Kathleen Holland and the commission prior to this? Why has he allowed these materials to be stockpiled without permits? Why has he allowed these materials to be maintained on the site in violation of the driveway permit? Why has he allowed Mr. Karp himself to get into the backhoe and dig these 5 test pits on the site without stopping him and reporting him to Kathleen Holland? This situation requires the appointment of an immediate independent engineer. Mr. Danaeus' firm is being paid by Mr. Karp to prepare this and design this 101 unit development that is going to be put on the site. There's no question about that. Mr. Karp can refuse to answer the questions all day long, but that is his intention. That's been his intention since 2014. I don't think this commission should act on this violation tonight without getting an independent report from an independent engineering firm. In addition, Attorney Smith seems to claim that our group has done something wrong here. This is a notice of violation issued by the town. This is not a permit application by our group whatsoever. Ms. Holland found that Mr. Karp and his company violated the conditions of the permit and did additional digging in the wetlands without additional permits. I don't have a burden of proof here whatsoever. This is a notice of violation. This is an enforcement proceeding. In addition, if the commission's going to find, without getting an independent engineering firm to verify what has been done here, then the commission should consider issuing substantial daily violations against Mr. Karp and his company for intentionally violating the terms and conditions of his existing permit, and for knowingly refusing to get another permit, which he's done a number of times in the past on this property. So I would request, number one, no action be taken tonight, that an independent engineering firm be appointed. There was no rejection of Commissioner Sillo's idea that he raised in the last meeting. We, as New Canaan residents against destructive development, specifically requested that happen. We specifically requested that Mr. Denea's firm be disqualified from continuing, as he has a serious conflict of interest. As a licensed engineer, he should have turned down the town's request to be the independent engineering firm or the site monitor on behalf of the town, given that he's the engineer of record on this project for Mr. Karp. It is a 101 unit development. In addition, he's also the engineering firm of record on the Weed Street property for Mr. Karp and his companies. So based upon all of those statements, I request an independent engineering firm be appointed, that there no action be taken tonight. And if you're going to rush this and go forward, closing your eyes to the actions of Mr. Karp and his company, then I request that you issue substantial per diem fines for the violations that have existed on that property for months.
Thank you, Mr.
Chairman, if I can respond.
Yeah, who said that?
Chris Smith.
Oh, I'm
Attorney-
sorry. Yes.
Chris
Yep.
Smith, Mr. Chairman.
Yep.
For the record, contrary to Attorney Durkin's representations that there was digging in the wetlands, there was no digging in the wetlands. I think we have to keep in perspective what we're talking about. There had been a permit issued by this commission to install a driveway. That was done. As we know, the next item on the agenda is Attorney Durkin's attempt to have this commission revoke that. What you're hearing tonight is that some test pits that were done in the upland review area, not in the wetlands area, that there were some holes dug, they were filled in, there's no adverse impact. And there was the material that had been utilized that was generated from constructing the access driveway that was approved by the commission. Some of that was stored outside of the limit of disturbance, wasn't stored in the wetlands. It was outside of the designated limit of disturbance. Some of it was even outside of the upland review area. Director Holland and this commission instructed my client to remove and restore that limited area in the upland review area, not in the wetlands. That was done. And as we've heard testimony with regard to the next item, the activity that has been done on that property today is within the scope and the activities approved by the commission relative to the crossing. So Attorney Durkin is just trying to create delay. There's no reason, absolutely no legal reason, or even a scientific one, to have anybody go out there and look at it. Your town engineer and your town wetlands director, and Director Holland has been there for many years. I don't know your town attorney or town engineer, have gone out there, and what happened? My client removed some of the stockpiled material from the upland review area that happened to be outside of the designated line of disturbance. There was nothing in the wetlands. There was no filling. There was nothing that even affected the wetlands. And as you've heard from the only expert wetland scientist that you even heard from, there has been no adverse impact to a wetlands. My client, jumped on this, took care of this, and there's nothing for anybody to do at this point except to move on. We were asked.
Well, unfortunately, Mr. Smith, I completely understand that, and I have no problem with it. I think that you guys obviously did everything in line. Our problem is, or at least my problem is, again, I'm a builder in New Canaan. I understand how these things work. I commend Mr. Karp for handling everything the way he did. I think he did it in a timely fashion. My problem is, unfortunately, that there is a conflict of interest. And guess what? To your point, Mr. Smith, this is now a done deal. And I think that you guys complied in the way you did. And I think that there was nothing wrong with the way you did. It would have just been nice to have a third party to say, hey, this is what we kind of give this the blessing, right? Compared to what the other engineer is saying. So I don't think anyone's going to say, hey, you did the wrong thing. I think the thing was a little reassurance, right? I think that it's done now. And I think Mr. Karp and his team are very timely in what they do. And I think they did it the right way. I just feel like it would have given everyone a little reassurance to say, hey, a third party for a small fee on, in Mr. Karp's association would have said, okay, great, we could have got this done. To assure the towns, to assure the community, right? And I'm not saying that it was wrong, it was right. I'm just saying it might have been a little extra insurance or a little extra assurance for that matter.
Kathleen, let me, I see Angela, just a minute. Kathleen, let me ask you a question. What was the third party oversight person written into this plan?
So let me just correct a statement that Mr. Durkin's made a few times, because I think it's adding some confusion to this process. The DeAndrea Engineering is not employed by the town of New Canaan. The town of New Canaan has not hired DeAndrea Engineering to do any oversight investigating. We are not paying the town of New Canaan, DeAndrea Engineering for any services related to the Hill Seat property. So there is no conflict of interest. Mr. DeAndrea's firm has been hired by Mr. Karp's association to be the site monitor for his project on Hill Street. That is a condition of your wetland permit that was issued back in 2017. So they are.
I don't think anyone's arguing that. I just think we're using a report that is made by someone that is being paid by the applicant, right? So again, this is a total sidebar. And again, I think to reiterate, I think that the CARP team has done a great job with remediating under Kathleen's supervision. So I'm not upset with that. What I'm upset with is we're using information that from a report that was being paid for by, and I don't mean to say Mr. Carr, it could be ABC company, it could be anybody, right? We're using a report that was paid for by someone else, right? So to Mr. Durkin's point, I think maybe he's being misconstrued. And at the same token, I think Mr. Carp is being misconstrued, saying we don't have a third party, independent party saying this is what it should have been and this would not should have. Now, again, total sidebar, what's done is done. It's obviously done correctly under Kathleen's supervision, but I think it could have been dealt with a little bit more delicately than it was. That's all I'm saying.
And just to go back to the June meeting, when this discussion took place regarding the possibility of a third-party reviewer, I think, Anthony, you actually had brought it up, and Angela and George Perkins opined on that. That seemed like a good idea. Attorney Smith went on to give his parts, and he can speak to that. I'm just going by what's stated in the minutes. And in addition, ultimately, the commission didn't make a special finding or make a recommendation or make a requirement that a third party be hired. I remember saying I don't have funds for that, so it wouldn't be something that the town of New Canaan could pay for. So,
well, again, it's to the fund, the funds or whatever. The cost would be to the applicant, not to the town of New Canaan, if we made that stipulation, right?
I guess what's the difference if DeAndrea is a certified engineer, and he is, Derek is a certified engineer, William Kenny is a certified soil scientist in addition to a landscape architect. I'm not looking to argue, Kathleen, but not. I'm not either. I'm just discussing.
If we made this decision, Mr. Karp's company would have had to pay for the third party.
The big difference here, Ms. Holland, is the fact that Derek Diazius his company is being paid by Mr. Karp to do the engineering to design the 101 unit complex going on this property.
Well, wait a minute. You don't know that. You don't know that.
Oh, I do know that.
Don't go there, okay?
Mr. Karp looked me in the face and the eye and told me that's what
Don't go there, sir. Don't go there.
So, and he's also being paid by Mr. Karp for the Weed Street development. So if you have an independent who is not working for Mr. Karp currently, even though Mr. Karp is ordered by the commission to pay for those expenses of a valid independent neutral site monitor, then that individual will engage his duties in relation to what he's been hired for the town as a site monitor. So there's a big difference.
Well, the good thing, Mr. Durkin, is that we have Kathleen on our side, right? And Kathleen obviously looked through everything and did the right thing and monitored all these things that when they cleaned up this situation or this violation. So again, Fortunately, but unfortunately, it is what it is, but we do have Kathleen on our side that did monitor everything. It seemed like they did everything as per the cleanup spec, I guess you could say.
The one thing that we're ignoring here is how we got here in the first place. Okay, it was our group that filmed Mr. Carp in the backhoe digging the test pit holes outside of the driveway area. And it was our group who had the mounds of materials on tape that we provided. So this is not a situation where the applicant comes to you with clean hands and came in for a permit to dump all of those materials outside the scope of the driveway permit and to conduct test hole periods, pits on the property that required another permit. So I just want to make sure everyone understands how we got here today.
It is cleared up now. It is taken off out. The refuse is off the property. Is that true? Is that true, Attorney Smith?
Yes, Mr. Chairman, and if we could go back in time and have had somebody else come out and watch my client take the material off and put seed down, I suppose we could have done it, but we never would have been able to do that timely, so we could be before you this evening and having taken care of that. And I would think that if anybody really was truly concerned about having that material removed as soon as possible, they would want my client to have done that. And working with the town, we did accomplish that as quickly as possible so that we could appear before this commission this evening as you requested and represent to you that this work was done. And again, I certainly understand the comments from the commissioners. And certainly if this had been something where perhaps there was activity in a wetlands where something had been dumped in there, it would be a different story. And again, I don't want to just keep reiterating it. I know Attorney Durkin will, he just wants to get something that's not there. I mean, there was
That's
some
right.
material outside of limited disturbance in the upland review area. We were told to remove it. I've seen it. It wasn't a huge amount of material. It was removed, and it was removed under the supervision and working very closely with your wetlands director. And again, your town engineer reviewed it. And I don't think there's anything to report. There was, in the wetland scientist, the only one wetland scientist involved, Mr. Kenny, is of the opinion that things were done properly and there was no adverse impact or impacts caused to the wetlands while that occurred, which was the goal of this commission and Director Holland. So, I would hope that we can move on from here. The work that you asked us to do, we did do, and we did it timely, as quickly as we could to beat this deadline.
Just for the record, according to Mr. Kenny, everything was done the way it was supposed to be done, correct?
Well, I think Director Holland was out there and observed the work.
And with Kathleen, yes. Okay.
Yes, sir.
Angela, yes, Angela.
I would just wanted to say, in fact, what Kathleen said, which is there was a discussion of appointing an independent monitor. Mr. Sillo raised it. Myself and Mr. Perkins said it might be a good idea. But then there was significant discussion about the fact that it would delay things, and also that we commonly rely on the reports of accredited experts as to whether something has been remediated correctly or not. And I think it was Kathleen who suggested that in addition to having that attestation by the engineer and the soil scientist / architect, landscape architect, she would also take the town engineer. So the commission never did vote on and say that as a condition that there had to be a third party monitor. And we had quite a robust discussion around that.
Kathleen, anything from you?
Do
you have anything to say?
That's my recollection as well. I mean, I brought Joe Zagorensky as an extra eyes, and he actually did some photographing for me, because I know this has been the discussion of much discussion. Yeah. So I feel very confident in my role as the director of inland wetlands that the remediation has been done appropriately, accurately. The grades have been essentially substantially established to what they were previously. I can't say much more about this. It has been resolved. And honestly, I believe that if post this rain event that we have had now. If there's an issue, I literally will pick up the phone and be in touch with the CARP team to identify any issues, and they'll be looking at it as well. So I see nothing further regarding the notice of violation, in that the matters raised in the notice of violation have been resolved.
Can you tell me as what percent of the plan of the work hasn't been done yet? Does anybody know that? Is everything been done? Except you seed it, so you can't do anything more than that right now.
Dan, it sounds like everything has been done, which is good.
Okay.
Right, Kathleen? I mean, everything's been done, right?
As far as in relationship to the items in the notice of violation, yes, they have satisfied the issues that were raised in the notice of violation. But Dan, I'm not sure if you're asking a different question, so you might just have to phrase it again.
Well, I was really talking about what we decided on in the plan. And we decided on the plan, everybody was for that plan in June. Now, and there was just a couple of things that seemed to me that needed to be done to get you in here and back in here. And one is to remove that refuse on the property. That was the main thing, it seemed to me. You did that fine, it seemed. Do you need a third party expert to judge if it's done properly, Mr. Durkin? I don't understand that. I don't.
Commissioner,
Yeah.
we have requested the independent monitor in connection with our application to revoke his permit. The Army Corps of Engineers has determined that he has violated his permit. And we submitted evidence from a licensed engineer showing that he violated the terms and conditions of his permit in the construction of the driveway.
We're not there yet. We haven't got
I
to
know.
that.
I was just going to
Yeah.
say, I'll defer to that discussion on the independent monitoring or site monitor for the town. So I'll defer to that discussion.
All right. So any other questions of the applicant? So we need to, if there's 5 of us, we need to kind of deliberate on what we just heard, and then make some sort of a finding on what we just heard, because it seems to me that what I just heard, everything's done. Everything's done. You did what you asked we asked you to do, and that's important. And I think that's a very important thing. You got it done. And I haven't heard anybody say that it wasn't done properly. So, does anybody on the commission disagree with that? Anthony, Beth?
I defer at this point. At this point, I defer to Kathleen. She knows more about
Yes.
wetlands. Again, me personally, would I have felt more comfortable with third party? Sure, but Kathleen was there. I trust Kathleen. She worked with them obviously very closely according to her notes. At this point, I have no problem.
Good. Peggy, anything? No? Beth? Beth Sanford, no? Okay, just shake
Sorry,
your
I'll
head.
unmute. I also defer to Kathleen's expertise and what she did in terms of overseeing the whole
We
remediation.
always do that. We always do that. That's nothing new. You're right. You're right. All right. So thank you. Thank you very much for coming in, explain what you did. I think what we'll do, we can take a vote, I guess. Pete, are you there? Pete,
Yes, I'm here.
oh, what do you think? Should we take a vote on this or just?
Yeah, I think so. If somebody makes a motion that states what seems to be the consensus, that the violation has been corrected, and everybody can vote on that motion.
Who wants to make the motion? Angela?
Yeah, I would like to move that the violation has been corrected in accordance with what the commission decided at the last June meeting, and that the procedure to have that inspected and vetted was followed. So I move that that violation has been corrected and remedied satisfactorily.
I'll second that.
Peggy seconds it. All those in favor, raise your hand. I think I see everybody. All right, motion's carried. Thank you very much.
Thank you.
All righty, so moving now to we move now to 9. And
Dan,
yes, yes.
really 8 had 2 parts. The petition for intervention was filed, the 22A19 petition, intervention petition was filed
Oh,
with
yes,
respect
I'm
to item
sorry, I'm
8.
sorry, yes.
So the commission
Yes.
should make a finding there.
Okay. So 8B says, commission to deliberate, I'm sorry, is that right? Commission to deliberate and make findings regarding notice of intervention. You all have a copy of what was sent around today, but let me just summarize it here. As to the notice of intervention filed by New Canaan residents against destructive development, when such a petition is filed under General Statutes Section 22A-19, the Wetlands Commission must determine whether substantial evidence exists in the record to make determination that the activities that are the subject of the commission's consideration are reasonably likely to have effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, and other natural resources of the state. So we're deliberating now, everyone, on the commission. Does anyone have any comments? The petitioner, it goes on saying the petitioner has the burden of proving such impairment or destruction through substantial evidence, which is generally deemed to be expert testimony. The commission is entitled to believe or not believe any testimony offered to it, or to give more weight to one expert's testimony over another. Well, one thing that comes out, if we follow that, the group did not have any expert testimony representing them.
Mr. Commissioner, we were denied the opportunity to be present during any of the reparative work or any of the proceedings going on. So there was no mechanism for us to have brought an engineer to make any observation and inspections of the work that was done.
So you're complaining that you weren't able to get on the property, is that it? Is that what you said?
Correct, correct. And in fact, Mrs. Holland has denied our opportunities or requests for a public site meeting and for us to be present. So I just, for the commission as to why we're incapable of filing a report as to whether full restoration has been done or whether there's been any damage or destruction to any wetlands areas.
Yes, Kathleen.
Dan and Pete more so, the notice of intervention is specific to the notice of violation and the record. So I'm a little confused on process here and whether or not, and not to mention, I can't allow anyone to go on anyone's private property. So Mr. Durkin, I've explained that numerous times to you and your group in writing, but so I'm a little baffled on what would be the next step, because they intervened on the notice of violation. Last month, the notice of violation was discussed at length, and they were given the opportunity to comment and provide comments. Per Dan, he did not hear any expert testimony in relationship to the specifics of a notice of violation. So I'm not certain that this goes on post the intervention happening at last month's meeting connected to the notice of violation and not related to now the interveners having the ability to oversee restoration. I don't know. I'm not certain of that. Pete, I don't know if you have any comments or thoughts on that.
I do. Generally speaking, when a petition under 22A19 is filed, it's incumbent on the petitioners to have information already in place that establishes that there's a reasonable, that activity is reasonably likely to cause unreasonable pollution or damage a natural resource. That's the nature of the petition under 22A19. It's not supposed to be a fishing expedition. It's supposed to be based on some expert testimony. So the time to have presented that testimony was at the last hearing, and nothing was presented. It really has nothing to do with whether or not access is granted to the site, because the petition was filed prior to the remediation. So it's incumbent upon an applicant or a petitioner to establish through expert testimony, which is substantial evidence, that there is a reasonable likelihood of unreasonable pollution. That unless there was expert testimony presented to the commission that I'm not aware of, that opportunity occurred at the last hearing. Nothing was presented. And as I recall, there was testimony offered at the hearing in June that the activity was not going to unreasonably pollute the natural resources of the state. So that's sort of the process. It's not access to the property is really irrelevant to the determination as to whether or not the intervention petition stated a valid claim.
Mr. Chairman.
Yes, Attorney.
Attorney Chris Smith, for the record. I wasn't planning to comment at this point in time. I thought we were done, but I would like to point out two things. One is something that Director Holland alluded to, which in 22A19 law here in Connecticut is right on point, that when somebody files an intervention under 22A19 into a proceeding, they cannot expand that proceeding into other issues. And again, this proceeding involves an NOV concerning two activities. They've been addressed. The commission just voted and found that, and they've been addressed to the satisfaction of Director Holland and your town engineer, as well as this commission. And I think that the sole expert testimony in the record from experts, and Mr. Kenny, again, is a professional wetland scientist and soil scientist as well, is that not only is the activity that did occur did not result in an adverse impact to a wetlands. That goes to your wetlands jurisdiction, right? As you're wearing your wetlands commission hat. But as to the 22A19 claims, well, there's nothing in those claims that indicate that the test pits that were done or the storage of the material from the construction of the driveway outside of the limit of construction designation resulted in the unreasonable pollution, impairment, or destruction of air, water, or other natural resource. That's what a petitioner has to do, and they have to work within what what has been filed. They can't go to wetlands and bring in the zoning issues. It all is focused on zoning and whatever the issue is before the commission. Can't go to there's a case called Nazardo, you can't go to the State Traffic Commission and expand what the State Traffic Commission is reviewing into a wetlands review. And with all due respect, and as has been indicated, I'm not sure of, and I used to do opposition work way back when, you can't get on the property generally. And Mr. Durkin was denied access when the Army Corps came down with deep, and he wanted to be on the property, as the Army Corps indicated, only if the owner indicated that anybody else could be on the property. Could anybody else be on the property? So there's nothing wrong with that. It's not relevant to the proceeding. Somebody files an intervention under 22A19. Quite frankly, when I did it, I have the responsibility to the board or commission that I filed that intervention with to do what you're supposed to do. And that wasn't done here. And that's the end of the story. And I respectfully submit that's the end of the story. And we've heard there's absolutely no substantial expert testimony to back up. You just can't make blatant claims that there's a violation of the statute and regurgitate the language out of the statute. You have to have some expert testimony. And right now, there's none. The only expert testimony is from my clients, 2 experts, that it won't result in unreasonable pollution. Quite frankly, they also testified possibly at a lower level, there's no adverse impact to a wetland or a water course. And I would respectfully request that the commission simply find that the petitioners, again, failed to sustain their burden of proof, and that we can move on. But thank you very much for the opportunity to comment.
You're welcome. Anyone else? Come on. All right. Let me look at my notes here.
Dan, there should be, somebody should make a motion as to whether or not the petitioner met his burden under 22A19. Someone should make a motion and you should vote on whether or not that burden was satisfied.
Angela? Angela? You got to turn on, you got to turn your.
I'm sorry about that. I move that the intervener did not fulfill the standards for the burden of proof in this case, and that the commission should conclude that.
Any
I'll
discussion?
second that.
Okay. Any discussion at all? All those in favor of the motion, raise their hand. Anyone not in favor? Anthony?
I'm in favor. Again, I just feel like I don't think it would be a big burden. I mean, these guys are professionals, right? I just feel like there wouldn't be a big burden to just have I guess a second opinion, right? But again, I think that the applicant has made a conscious effort by hiring these guys to handle this stuff. I just feel like it would be a very incremental cost to say, hey, let's just make sure we're all on the same page, but I'm in favor.
Okay. Peggy, got anything?
I guess my only question, Anthony, you'd want a third party to just.
Again, I just feel like I'm not trying to be a thorn in anyone's side. My thing is to people's points, we just want, I think not we, I think that the group wants to be reassured that everyone is on the same page and everything's done the same way. I know that Mr. Karp and his team has obviously paid independent people, and I am all for that. What I'm saying is it could be a small incremental cost to keep Mr. Durkin and say, to keep his mind at ease to say, hey, yeah, we did this, right? We spent the extra $5-10 grand and said, hey, we did this. We got our third party in. What's the big deal? As long as it keeps Mr. Durkin assured that nothing happened, right? Again, I'm all for it. I think Kathleen does a great job. I think that Mr. Karp obviously did his third-party people. I'm not upset with that. What I'm saying is, as a small concession, maybe it would be the right thing to do to have a third party come in and just say, yep, check the box, everything's all good, right?
So are you, just a quick question, Anthony, you mean a third party soil scientist or an engineer?
Sure. I mean, I think at least that, I mean, engineering is the engineering. Everyone knows that. It's numbers, right? It's numbers and I've done plenty of that. It's more like the soil scientist, just to keep Mr. Durkin's group assured that there's nothing wrong. And I think that'd be a small task to say, hey, yeah, Mr. Durkin, we've done this. The soil's good. We've done everything we're supposed to do. We know we've done everything we're supposed to do. But again, if that doesn't work, and it doesn't work, you know, I'm not going to tell Mr. Karp or Mr. Durkin how to run their lives or their business. I'm just saying maybe it would be a nice way to a nice gesture, right? That's all.
Hi, this is Beth Sanford speaking. If in terms of what we've just been talking about for the last 10 minutes, we listened to the guidance of our town attorney. What we were told is that the burden of proof should have taken place at the June 20th meeting, and it's really a moot issue now. So it's not a matter of going in and making that proof. It's a different issue than the first part that we discussed.
I would agree, Beth,
So,
and it is done. So I mean that's all we can say. It's done,
right.
And it's done correctly on the oversight, which I'll say again, on the expert oversight of Kathleen and as per the third Karp's experts, right? So there's nothing more to say about it, you know.
But the burden of proof should have been that there was adverse pollution, that it's affect our, you know, air, water, trust in air, water, and other natural resources should have taken before this whole remediation.
Understood, but we understood, and we don't know that. And I think that's the frustration of Mr. Durkin. I don't know Mr. Durkin. I've never met Mr. Durkin. I think his point is we just don't really know. And I can guarantee you, Mr. Karp has done everything properly. I can guarantee you that, because he's a long time builder and developer in New Canaan. I grew up as a child knowing Mr. Karp, right? My thing is a little reassurance, and last meeting would have done that, would have put Mr. Durkin's group at ease, right? Now it is done, and there's nothing more to say because we won't know, and there's nothing to know, but it would have put him at ease a little bit more, right? And I know Mr. Durkin has a lot of great points, but that would have solved a lot of his issues, right? So for a small concession, we would have been able to deal with that. Now, again, am I faulting anyone? Absolutely not. I'm just saying it would have been a nice gesture. That's all.
I guess the issue is at what point or in which cases do you bring in a third party when you have the town expert to review things? I'm probably on mute. No, I'm not. Okay.
I feel like, again, I think it's a lot. Kathleen has a lot on her plate. I think this was a very hot button issue. I think that sometimes, and Kathleen, correct me if I'm wrong, or if you're uncomfortable with me saying this, I feel like it would have been a nice reassurance for Kathleen as well to have a little backup on this, just to say, hey, we checked everything. Kathleen was right. We're good. There's no problems. I mean, everything can't land on Kathleen as well. I mean, this commission, we rely on Kathleen a lot. And you know what? I feel like she does her job very, very well. I just feel like maybe she didn't need to have all this turmoil, right? Maybe she could have had a little bit more help with a third party, right?
We did have considerable discussion at this very point, Anthony, at the June.
I just don't feel like it was actually resolved.
And you put forward the argument there. And initially, some of us said, yeah, well, that's a good point. And then we had further discussion, and there were reasons why it didn't sound like it was necessary or such a good idea. And at the end of the day, the commission didn't decide to go down that road. That was when we should have gone down that road.
I don't remember.
Had we been going to do that?
I've been very quiet on this commission for multiple months. I don't have a problem with it. My thing is, I have a problem with not even, we didn't really vote on it. We just kind of came to that conclusion. That's something for the commission to deal with, and I don't have a problem with that again. I think that this is a done deal. And I think Mr. Karp did a good job of, with Kathleen's oversight again, I think he did a great job of doing it. I think Kathleen did a great job. I think for this commission to talk about it later is a whole different thing, and that's fine.
But just Sanford speaking again, what we're discussing now is whether the petitioner presented without a burden of doubt that there was impairment or pollution. And that was something that should have taken place before. It has nothing to do with oversight that's happened between then and now. So again, it's something that is part of the process and is in the past, and it wasn't done at that juncture. So it's not an issue now. Unless I'm mistaken, that was not proven to any degree.
I completely agree.
Pete, Pete, let me ask you, I throw this out. Is it a done issue?
Well, yeah, that's really a commission decision. You already voted previously, you already voted on the issue of a third party reviewing this remediation, because that was the first step. That was voted on. It was unanimous. That part, I'm not sure why it's being revisited now, because the issue now is whether or not the applicant or the petitioner sustained his burden of establishing a reasonable likelihood of unreasonable pollution. And as I think everybody said, there was no evidence offered to that effect. That's a separate issue. As Beth pointed out, that's an issue with respect to whether or not substantial evidence has been presented to the commission. It's a commission determination as to whether or not it was. And if it wasn't, then the commission, without that substantial evidence, there's no basis on which to determine that the intervention petition had any merit. So that's,
I got it.
That's all I'm saying.
All right, thank you. Thank you. All right, we voted on it. I guess we just raise our hands, all right? Yes, Angela. You're raising your hand?
I'm raising my hand in favor of the motion.
In favor of the motion. All those in favor of the motion, raise their hand. We got five. We got five. So 5 out of 5. Thank you. Motion is carried. Number 9, 17 and 23 Hill Street LLC, petition to revoke inland wetlands permit 17-18-53 issued to Hill Street 72 LLC. New Canaan residents against destructive development. This is continued from the June meeting. We've completed the presentations. And again, like in number 8, commission to deliberate and possibly vote on petition to revoke the permit. Does anybody want to start, or do you want me to keep going? Okay, let me just throw this out. In considering item 9A, the commission, and maybe this will give you some ideas and to start a discussion. The commission should consider if there's any credible evidence that the permit was acquired through deceptive or through inaccurate information as to either the activity or its environmental impact. And to stimulate some discussion, here are some points that important facts to consider. At the hearing on the application of 72 Hill Street LLC to conduct a regulated activity, the applicant represented to the commission that the purpose of the driveway was to service two proposed single-family houses. That's a fact. That's at the time. The next point, at the time the application to conduct a regulated activity, parentheses, a driveway crossing, was presented to the commission, there was a moratorium in effect that precluded an affordable housing development under CGS 8-30G from being filed. To date, the balance of the property has not been developed. That's another point. Another point, the applicant has stated that he has not yet determined the use of the property. And there is no evidence that at the time the hearings were held in 2018, the applicant misrepresented the proposed use of the property. And the final fact, and there may be others, in the event the property is developed in the future, this is important, the applicant will be required to return to the commission for review and approval if the development differs from the activity approved and authorized under permit 17-18-53. There may be other facts that we want to add to that or consider. So anyone want to start discussion on any of those? Well, I personally, I went back in history and went to 2018 and checked the meeting notes, the meeting minutes, and we worked on approving the permit for a 16-foot driveway in 4 different meetings, and I went through that, and I saw nothing there that I could see was inaccurate or not, or just plain old false today. Okay, so I'm I've seen nothing in my own reading and things and talking that there's no credible evidence that deception or thorough inaccurate information was used in getting and gaining the permit. Any comments? Anthony, nothing?
It's always
Yeah.
me, right? I don't know. One of these
What?
asks me.
Yeah.
No, so I again, as of right now, I don't know. We don't know what the LLC or Mr. Carr, whoever owns the place, is going to do with it. So yes, as of right now, you're correct. As per the approval of the crossing, we don't know what's going to be there. It could be two family, or two single family houses, right? It very well could be, and that's what it could be, and that's what this commission should be deciding on right now, right?
That's right.
It's not what could be there, it's what is planned to be there and what is, what was approved. If that changes, then I don't know the whole process. Do we have to come back here? I don't know. But as of right now, it's in compliance as per the 2016, which I wasn't here for, but the 2016 approval, correct, Dan?
That's right. Angela?
I would just add that it's a very high burden of proof to actually conclude that we were deceived, that or that there were very significant misrepresentations. As Mr. Chair said at our last meeting, you know, none of us can get inside the head of Mr. Karp or anybody else that is involved in this development, and it's incredibly high standard, it seems to me, that has to be met in order to conclude that there was deception or misrepresentation.
You know, in going in the background, I kind of forgot how this worked. You know, we had approved a 12-foot wide driveway and in 2014. And then Mr. Karp bought the property, and his firm came to us and said, you know, we'd like to have you extended from 12 feet to 16 feet, okay? For safety purposes. Obviously, for marketing purposes too, there's some, you know, other other motives there. And I kind of forgot that. And so we now, you know, we had approved a 16-foot, and then the property was sold by McLean's, I guess, to Mr. Karp, and right away he suggested, he came back, he said, I don't want that permit. I'd like to have you consider another one. So that, to me, that was a solid idea. He did it for safety, and what I learned in the meeting notes. Okay, so.
Hi, this is Beth Sanford speaking again. I just have a question. At what stage, if the plan goes from being 2 single-family homes to a much bigger development, at what stage would they have to come to us with a proposal for a new permit?
I don't think, do they even have to, because it's already, the crossing's already complete, right? I mean, it's done, right?
It's the last point of what we read was what Dan read was that in the event of the property is developed in the future, the applicant would be required to return to the commission for review and approval if the development differs from the activity approved and authorized under permit 17/18/53.
Can I comment, Mr. Chairman?
Who said that?
It's Pete Gelderman.
Peter, okay, go ahead.
The answer is if a new development has any different impact on the wetland or the watercourse than what was previously approved, the applicant will have to come back. And that impact could be activities within a regulated area. It could be activities within an upland review area. It could be activities outside of the upland review area if it's determined that those activities will have a negative impact on wetlands and watercourses. So it really, at one point, will they come back? Well, they'll have to come back if they present an application that does any one of those 3 things. And they'll have to come back and modify the permit because that activity has not been approved yet.
Right.
Modify or apply for a new permit. We won't know the particulars of an application that we don't have. So I don't know how to fully answer Beth's question, but Pete did summarize those.
Mr. Karp, do you want to surprise us and make an announcement tonight?
Mr. Chairman, the public hearing is closed, so you shouldn't be getting any comments from anybody other than discussion among the commission members at this point in time.
Okay. Sorry. So, do you, oh, let me ask you this, do the four of you out there have enough information? Have you thought about it enough? Have you studied enough to take a vote tonight, do you think? Or do you want to wait? Now, we don't have a meeting in August, so it'd be September before we took the vote.
I'm not sure that we're going to get any more evidence, come another meeting. I think the burden that we have credible evidence of deception or inaccuracy of an activity, that's kind of a high burden to meet. And I'm not sure that we have that when we gave the permit. So I'm not sure if we have enough to revoke a permit at this point. I don't know how anyone else feels.
Anthony? I hate to keep coming to you, but you
again,
look
I
like
think,
you want to
again,
say
I will
something, okay?
I'll say what I said before, and that is if the plan is to do 2 single-family dwellings, that this thing is approved, right, by the Wetlands Commission in 2016 for a 16-foot wide crossing, right?
Yep.
So I guess if we're voting on a crossing from the plan that we're doing 2 single-family dwellings, that's the information we have given right now. And to Kathleen's point, that's the only application that's in right now, right? So I think that we need to, I think Kathleen's smart for saying it, and you know what? This is the information that we have, right? So this is what we need to vote on. I don't think that we're going to get any more information on this at the present date, right?
It seems to me, I think you're right. Angela?
I just want to make the point that we gave the permit in relation to 2 single-family dwellings. And that on that basis, we agreed to the permit. I, for one, will feel very upset, chagrined, if we find out that in the end, we approved a permit that will allow a substantially different, bigger development to be constructed on that site. And I wish I felt that I had 100% ironclad assurance that if it's not going to be 2 single-family properties, then the applicant will come before us with a new application. I don't feel we've got that 100%. I think we're kind of feel that, well, it's highly likely he'll have to, won't he? But doesn't quite feel like 100% to me.
So Angela, the big thing is here, a standard driveway for a residential house is 12 feet wide. If you want to get 2 cars through a driveway, it's 14 feet wide, right? A 16-foot wide driveway would be a whole nother thing, right? I don't know any residential house in New Canaan that has a 16-foot wide driveway. 14 feet is plenty to get 2 cars past each other in a residential driveway. The problem is that we are using information that we have been given since 2016. Now, if something came about, right, or there's a development, unfortunately, this crossing has already been constructed and been approved to cross the wetlands area. That's my issue, right? So now it's there and it's been approved and it's there and I can't see it going anywhere.
Well,
So
I think that's everybody's issue, Anthony.
Yeah, so
that there may actually be a permit in place that allows a very different development to take place. But I would argue that a significantly larger development would have very different kind of impact on the wetlands, on the regulated area, on the upland review area, and therefore the applicant should come back to us. But I say should. Does that mean that that will happen? Who knows?
Again, Angela, I agree with you, and I think we're dealing with the information we're given right now, and that's what we have to vote on tonight.
Well, since this is not a public hearing, we can't ask Mr. Carp or Mr. Smith anything else, I guess, so. There's no,
You're saying you'd rather rely on a lack of information than actual information? I'm confused.
No, we have all the information for the current plan that's in place, which is 2 single-family dwellings.
Let's not,
Right? If the
everybody, let's
plan
not get
changed-
into discussions. Let's not engage in anybody who's not on the commission. The public hearing is closed. So it's not appropriate to engage with anybody at this
I
point in
don't,
time.
are we, I don't think that we're engaging with anyone. I think we're saying this is the information given and this is what we should vote on. I don't think we're engaging with anyone.
wait a
are we?
minute, the question was asked by Mr. Stein, okay? So he's not one of the
No, I
five-
think it was somebody else. I think it was somebody
I'm
else,
sorry.
Dan, but
No,
it wasn't a member of the commission. There's
Yeah.
no opportunity for anybody who's not on the commission to make comments after the close of a public hearing.
so Peggy, you think we're not, we have about all the information we're gonna get tonight and probably nothing more. No,
I don't know what further information, I mean, nobody, I think none of us like this. I don't think we're gonna get any additional information. And, based on what we need for the evidence to revoke the permit, I don't know that we have any credible evidence right now, of deception or inaccuracy of the activity, because it's still for 2 single-family homes.
right. Angela, any other comments? No?
No, I think if we defer the decision, we're just going to go round and round in circles. Come September, as we're doing now. Seems to be the case that we go round and round in circles on this particular property every time it comes before the commission. So I think we should go ahead and make a decision. As I've said before, it's a very high, burden of proof that to say that we were deceived, and that's what it would take to, agree to revoke the permit.
Beth, did you have anything you want to?
Well, I'm still looking at what was the outline that was sent to us this afternoon. And the first point is that the applicant represented that to the commission that the purpose of the driveway was to service 2 proposed single-family homes. And so we're trying to vote on whether there's been adequate amount of deception in getting that permit, and we don't know the answer.
That's right.
And it
that's right.
doesn't seem that there is and again, I'm one of the newer members on the commission, that there is a catalyst that will make him come back to us, or the petition to come for a new permit. And I don't understand that part of the equation of what would, if it's not those terms, how the process would happen so that we could reevaluate the permit and the potential damage and pollution to the area. So I find it a hard vote to vote on, right?
Anthony, anything more?
I mean, Angela, I kind of look to you because you're kind of a seasoned veteran on this commission, you and Dan as well. I mean, I don't, to Beth's point, I don't know, should we put some sort of stipulation in, like if it comes back, then we have to revote? The work is done, like to me, I'm a simple man. The work is done, right? So should we say yes, if it accommodates 2 single-family homes, should we come back? And if it's something different, we have to go around the ring, around the carousel again. I don't know, but Angela, you're the compass for me on this one.
Well, I think it's very binary, either we revoke or we don't revoke. It's not like a, typical discussion of an application and there is this aspect that we're not quite so happy with. And so let's have a special condition, This is different. We have to decide whether to revoke the permit or not. It's very high burden of proof to actually say that the permit was given, under false pretenses, as it were. And as you say, I mean, the driveway is built. And we have been told that if the activity is going to be different, the actual development, the applicant will have to come back to this commission for a new permit. And that's what I'm hoping for.
I don't think the fact that the driveway is built is a conclusion or because if there, 4 cars driving over that driveway every day versus 202 or whatever it might be, it's a completely different effect on the surroundings. So I don't think that we can say that's concluded just because the driveway's there. It's what's the development that's going to be there.
But the
issue
question
really what
is,
affects the wetlands, though. So,
And I just want to add, the commission should be careful not to speculate on potential activities at a location when they're trying to determine whether or not this permit that the applicant currently has, you're trying to decide whether or not there was deception when they applied for the permit in 2018. And I think point number 2 is interesting on the sheet regarding the fact that there was a moratorium in place. So I'm not sure how someone could have provided information on a future development with a moratorium in place. And we still don't have an application for this location. Anyway, just be careful with speculating on pending potential applications for any location.
I think that's a very useful piece of advice, and thank you for giving that. So all I wanted to say about the fact that there was a moratorium in place, sure, but that wouldn't have stopped any other multifamily development that perhaps the owner might have wanted to construct. There's other kinds of multifamily development besides affordable housing.
true.
But we were told it's 2 single-family homes.
right.
That's what we were told, and is there really enough evidence to say that we were misled, deceived, lied to? That's extremely high burden of proof.
Yeah,
Let me-
so at the end of the day, we need to assume, which it seems like very strongly that there's going to be 2 single-family houses there.
Yeah. Let me just maybe finish some of the research I did. Mr. Carp bought the property from a man, a Mr. McLean. And I believe Mr. McLean, wanted to build a 12-foot driveway, but it was his maps that had 2 residents on the hill, okay? And it appears that Mr. Carp just used that because he wasn't going to change it, I guess, because of the moratorium. But I don't know. He could have done anything, I suppose. But he used something that was already on the maps when he bought the property. Okay. All righty. So let's vote.
So I guess we're voting on whether to deny or accept the petition to revoke the permit.
Peter, are you there?
Yep, I'm here.
Okay,
I think that's the vote, a vote whether to revoke the permit or not. So it depends who phrases the motion. So if the motion is to not revoke the permit, then people who vote yes would be voting not to revoke it. If the motion is to revoke, then people voting yes would be voting to revoke it. But so whoever makes the motion, just phrase it in a way that it's clear what a yes or a no actually means.
Angela, do you want to make it? You want to phrase it?
Sure. So I move that we do not revoke the permit.
Is that good
Or
enough,
maybe
Peter?
that the petition to revoke the permit be denied.
Sure.
Should any of the reasons for your decision be incorporated into your discussion? I know you've had it in advance, but is there a need to repeat or add any comments in that regard, Pete?
Well, it's always helpful to have reasons for a decision, especially a decision to deny. So Angela, having made the motion, maybe you should articulate reasons for denying the petition. And then the balance of the commission in voting, it should be clear that they are adopting those reasons as their collective reasons for denial. So it would be helpful if there were specific reasons attached to the motion.
Okay, so the reasons attached to the motion is that we have not been presented with sufficient evidence that we were misled or deceived when we voted to provide the permit in 2018, I believe it was.
Is that all right, Peter?
So we're voting not, so just to be clear, we're voting not to revoke the permit on the current plan for the property, right?
Yeah, I think Peggy suggested we rephrased it to that we do not grant the petition to revoke. Is that right, Peggy?
I said the petition to revoke the permit would not be revoked, correct?
Would not be not revoked. Could you rephrase that? I want to make sure we got all our negatives in the right place.
Okay. Let's see, why don't we say just the petition to revoke the permit would be denied. We would vote to deny the petition to revoke the permit.
Okay.
Based on
No
the reason
credible
that
evidence,
Angela,
Yeah.
no credible evidence of deception or inaccuracy of activity.
I would say insufficient evidence,
Okay.
but you know, I'm wordsmithing.
Do we want to add that based on the development plan that was originally proposed
And is still on file.
as a reason? Or the
That's
backup?
fine. We could add that.
Well, I mean, we could list some of the points that we have in this paper here too. We could list them all, really. Such as no, I maybe not. We'll leave it the way it is then. We'll leave it the way it is.
I kind of feel the simpler the better, but I'm, you
Yeah,
know,
yeah.
maybe other people see it differently.
I agree with
Kathleen,
you, Angela.
can you read that back now? Do you have it down? Can you write it down? No?
I'm sorry, I'm trying to work it out here. I don't know that I caught it incomplete. I have
Or read us what you got.
the petition to revoke the permit is denied. First statement, that's I think what you all are saying. And then Angela said that the applicant had not presented, she sort of said it in the reverse. The commission was presented with insufficient evidence to issue the permit. I don't know.
No, insufficient evidence of deception or misrepresentation.
Okay.
But if other people feel it would be better to say based on no credible evidence of deception or misrepresentation, happy to discuss that too.
Insufficient means there may be something out there. Well, I guess there would. That's what.
Can you do that one more time?
Do it again.
Okay, so the commission denies the petition to revoke the permit based on insufficient evidence of deception or misrepresentation.
Should we say the permit number that it's under?
Yep, could. I don't have it in front of me. I expect Kathleen does.
Kathleen does. Yeah.
Permit number 17-1853.
Okay.
So did you, that you've made the motion. I don't know if you had a second and then a vote.
I just wanted to, I think we should just expand that a little bit. No credible evidence of deception or inaccuracy of activity or environmental impact, and maybe put at this time.
Environmental impact is not really an issue in terms of revocation at this point in time, Peggy. I think
Okay.
the rest of what you said is fine.
So what did you say about inaccuracy, Peggy? I missed that. Sorry.
Inaccuracy of activity, I think was what Dan had read early on, or as a petition to revoke a permit. Credible
So
evidence.
how can activity be inaccurate?
Well, I guess if someone's representing they're doing one thing and they're doing something else with the property. Is the way I would read it.
Planned or proposed activity, you have to define it.
Yeah.
So if I summarize it based on the comments here and add what you would like, the petition to revoke permit number 17-1853 is denied on the basis that there is no credible evidence that the permit was acquired through deception or through inaccurate information as to either the activity or its environmental impact.
That sounds good.
But Pete doesn't like the environmental impact, not environmental.
So
Let's take
inaccurate.
that. I would take that bit out, the environmental impact out.
So
I mean, all we basically are saying it is that there wasn't credible evidence that we'd been deceived. Or, you know,
no credible evidence that the permit was acquired through deception.
Or inaccuracy of activity.
Of proposed activity.
Proposed
I
activity.
would use the word misrepresentation too.
Okay.
One more time, Kathleen.
I'm going to have to ask someone else to give that to me one more time. I have the petition to revoke the permit is denied on the basis that there is no credible evidence that the permit was acquired through deception or through inaccurate activity. Is that what you want?
Or misrepresentation.
Misrepresentation of planned activity.
Or misrepresentation of planned activity.
So maybe it would say inaccuracy or misrepresentation of planned activity. And maybe add no credible evidence at this time of deception or inaccuracy.
It's really at the time the permit was issued that's relevant.
Okay.
Right.
Okay. You want to try it one more time, Kathleen, or you got it?
Whew, okay, I do not do shorthand, and unfortunately it's changed several times now, so I honestly not sure I have it completely correct. I'll read it very slowly. The petition to revoke permit 171853 is denied on the basis that there is no credible evidence that the permit was acquired through deception or through, I think you said, inaccurate activity or misrepresentation.
Misrepresented activities, yeah.
Or through inaccuracy or misrepresentation of planned activity.
Whew, through inaccuracy.
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 Yep, inaccuracy.
Or misrepresentation of planned activity.
Or misrepresentation of planned activity. And no credible evidence was offered at the time the permit was issued.
I don't know that we need that.
I don't think we need that.
Not
don't
in
need
that
that.
language, but the misrepresentation relates to at the time the permit was issued. If there was, what you're finding is that at the time the permit was issued, there was no credible evidence of inaccuracy or misrepresentation.
Okay.
So just start the resolution with at the time at the time the permit was issued. You're revoking a permit. The theory being that it was improperly granted. So if the basis is misrepresentation, the misrepresentation is at the time the permit was granted. If you're finding there was no misrepresentation, the relevant time period is 2018 or whenever the permit was issued.
But it does say here that if the plan changes, he's required to come back to the commission with to get a new permit.
Yeah,
So-
if he probably will have to do that, but that's a separate issue. That's an issue as to whether or not he can go forward with anything other than 2 single-family houses, which is a separate issue as to whether or not the permit that was issued in 2018 should be revoked.
Okay, Pete, let me see if this nails it a little bit further, based on what the comments I just heard. The petition to revoke permit 171853 is denied on the basis that there is no credible evidence at the time the permit was issued, Nope. Sorry.
No credible evidence that at the time the permit was issued.
At that time, the permit was acquired through deception or through inaccuracy or misrepresentation of planned activity.
Yep.
One more time, Kathleen, go ahead. Something didn't ring right there to me, but
The petition to revoke permit 171853 is denied on the basis that there is no credible evidence. At that time, the permit was acquired.
issued.
Permit was
At the time.
At the
Kathleen,
time,
there's no credible that at the time the permit was issued.
issued. But then it goes on to, I had the next sentence I have is through deception or through inaccuracy or misrepresentation of planned activity. I think there's something missing.
Well, then say as a result of.
As a result of. Okay. One more time. The petition to revoke permit 171853 is denied on the basis that there is no credible evidence at the time the permit
That at the time.
that at the time the permit was issued as a result of deception or through inaccuracy or misrepresentation of planned activity.
I think it should be inaccurate, not inaccuracy.
I think there was something a little strange in the middle there.
It'd be good if we could type it out.
What about something like this? The petition to revoke the permit, whatever the number is, I'm sorry, I can't read my writing, is denied based on no credible evidence that at the time the permit was issued, it was obtained as a result of deception or through inaccuracy or misrepresentation of planned activity. Does that
I
work?
think I like that. I think I like
Yeah,
that.
that's good.
Pete, you good with that?
I am.
yeah. What,
So you have a motion. I don't know if you have a second, and then a vote would be your next step.
somebody made a motion, and somebody seconded it, right?
Well, the motion was modified, so it
Okay.
should be seconded as modified by Angela in her statement. Angela made the motion, she modified it. Now someone should second that modified motion, and then there should be a vote.
Beth, do you want to do that? You want to second it?
Yes, I will second it.
All those in favor, raise your hand. Motion is passed.
Thank you very much.
Thank you.
Attorney Gilman,
right.
Quick question. Are they going to issue a written decision or a written resolution on what was just adopted? Or is that the actual resolution that's being issued this evening for purposes of the appeal period?
What, I mean, what do you mean? Send it to the paper or what do you mean? What are you saying?
Is there going to be a written decision encapsulating the resolution that was just adopted? That will be issued, I assume, within the next few days. Or is this the actual resolution that you people are adopting tonight for purposes of starting an appeal period?
I don't know.
The appeal period starts upon publication of notice.
Thank you. Okay, thank you.
All right. Any other questions? Any other comments about that? Okay. All right, moving on now. We still got a couple of things to go over. As I said earlier, number 10, 11, and 12 on the agenda are New Canaan applications, town of New Canaan applications. And what we're going to do is move those to September, but I'd like to have, and I think we should have a public hearing on each one of those, on these three. So I need a vote from someone, I need a motion from someone to go to a public hearing on these three applications.
And I would probably read them one by one. It will be three separate public hearings that will all take place at the September meeting. I just feel that these are town of New Canaan projects and typically are a matter of public interest. And so it's advisable for the commission to vote to go to a public hearing in case some of the new members are wondering why we're having a public hearing on these items.
Application number 212250, 64 Richmond Hill Road. That's Mead Park, town of New Canaan. Map K block 10 lot 911. Remove accumulated sediment from 4 bays within Mead Park Pond. Tiger Man, Director of Public Works. We'd like to go to a public hearing on that. A number 11 on here. The second one, application number 212251, lot 616 East Avenue, and in parentheses, that's Mill Pond. Town of New Canaan, map R block 213, lot 616. Remove sediment from 4 bay within Mill Pond. Tiger Man, Director of Public Works. And the third one, application number 212252, lot 22 Oak Ridge Road, parentheses, New Canaan Nature Center, town of New Canaan, map 32 block 20. Demolish portion of existing boardwalk and replace with new boardwalk. Tiger Man, Director of Public Works. So should we vote each one on a public hearing, do you think? Or
Just two comments, Dan, on the, I just want the record to reflect that Beth Brunelli has rejoined the meeting for item 10, 11, 12, 13, and 14 until we adjourn. Also, for item number 12, Anthony Silla will be recusing himself on that matter because he's has conflict with activities at the Nature Center. So he won't be voting on that in case you're wondering why he's not voting. Anthony's fairly new, so I'm just letting it know, letting the process know that he won't be participating on that particular application. So yes, you should do individual votes for those, for the two items, and then the third.
application number 212250, 64 Richmond Hill Road, Mead Park, town of New Canaan. Remove accumulated sediment from 4 bays within Mead Park. Tiger Man, Director of Public Works. Can somebody make a motion that we go to a public hearing on that?
I'll move that it be set down for a public hearing.
Peggy, and
I'll second it.
Beth seconds it. Beth Stanford. We'll go to a public hearing. Application number 212251, lot 616 East Avenue, Mill Pond, town of New Canaan. Remove sediment from 4 bay within Mill Pond. Tiger Man, Director of Public Works.
Again, I'll move that it go to a public hearing.
I'll second that.
Angela seconds it. And then application number 212252, lot 22, Oak Ridge Road, New Canaan Nature Center, Town New Canaan, demolish portion of existing boardwalk and replace with new boardwalk. Tiger Man, Director.
Again, I'll move that 2122-52 go to a public hearing.
Right.
I'll
Peggy,
second that. I
who
can
seconded
that.
Beth? Who did?
That's Priscilla.
Priscilla.
Priscilla. Where, oh, there you are, okay.
Priscilla is actually not seated at the moment. So if we could have, sorry, if we have someone else.
I'll second it.
And
Beth
then,
seconds it, okay. Back to Sanford, okay.
and then call for a vote.
Yeah, all those in favor? Aye.
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 Motion's carried. All righty. Kathleen, is there anything you want to?
Should we have voted each one individually because we proposed them individually?
Yes, I think you just sped along a little too fast. On item number 11, you had a motion by Peggy, a second by Angela Jameson, but you didn't call for the vote. So if we could just do a full vote on that one as well.
All right. Who's it? Can I make a motion? Can you make a motion on application number 11 or 212251?
I think the motion was made. I think
We
we
just
just
have to
didn't
vote.
vote on it. We need to vote.
Just vote. All those in favor? Raise your
Aye.
hand. Aye. Okay, Kathleen?
Thank you. Okay, so administrative reports, 1, 2, and 3. Couple different activities continue to be a very busy season with lots of activities. You can take a read of those and let me know if there's any questions on the administrative permits that have been issued.
All right.
So I just had a question on item number 13 at Thayer Drive.
Mhm.
So the addition is actually going to be inside the upland review area, is that correct?
Correct.
But didn't appear to pose sufficient issues relating to the wetlands for it to come to the full commission. Was that a correct supposition?
Correct. And the back history on this one is I've been working with these folks for about 2 years on their opining on how to do an addition at their particular location. So they have an engineer, an architect, and one of the benefits of the shallow depth crawl space that's being done in that location and allows the excavation to not be overdug and be made closer to the wetlands than it absolutely needs to be. So they have a full vetted plan, engineering plan showing the access route in. There's no compromise of the wetlands on the site and will allow the family to have some additional space to have a family room of sorts. But even with that, it's still 21.5 feet from the wetlands at that location.
Thank you.
Any other questions, comments? All right, remember, before we adjourn, just remember that there's no August meeting. The site visit will be on September 7th and we meet again on September 19th. Thank you, everyone. Thank you very
all.
much. Thank you.
All right, thank you.
I'm glad
Thanks,
we don't
guys.
have
Good
to
to see
drive
you.
home.
Yeah.
Starting.
I hear
Bye,
the thunder
everybody.
out
Have
there.
a good summer.
Bye,
Thank
everybody.
you. Bye-bye.
Bye-bye.
Bye.